In this video, we will review 3 different hearings held in the courtroom of Judge David Fleischer of the Harris County Criminal Court in Houston, Texas. In these cases, we see what happens when defendants flagrantly violate the trust of the court, or even worse, hurt someone being careless with their actions. Our first hearing was in August 2024 after the defendant, Crystal Ann Sanchez, was charged with drive while intoxicated.
Fatality as a result.
Yes, sir.
Can you please read to me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a 4-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact. Massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol in her breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving?
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at a 0.025 for ethanol, and she had, yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer you worked out?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
I don't think that's enough. The fact that there's a dead body in this case, why is it not an intoxication?
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not gonna say it. You have a dead body here. She has cocaine in the system. She's got booze in the car while she's driving and a dead body. I'm not down with that. No, we're gonna have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication manslaughter. But to me, a week is insufficient. It's not enough.
Yes, sir.
So
We'll go back to the drawing board and get
go
it
back,
reset, Judge.
but
Yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you're
Unavoidable?
yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a 0.20. She's at a 0.2.
0.025, Judge. .025.
Point oh two.
Yes, sir.
Okay. I thought you said point two.
No, sir, no, it's .025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, Your Honor.
We were discussing about Ms. Sanchez. We were discussing when for you to do your jail time. Should we have you do it immediately to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? You know, what's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation. And that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You know, you're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. We're gonna have to figure out something about as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. When are you set to deliver, ma'am? What day?
August 28th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. It gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense, guilty or not guilty? And we'll find you guilty. We'll send you to this agreement. Good luck to you, ma'am.
Ms. Sanchez pleaded guilty to driving while intoxicated under Texas Penal Code Section 49.04 and received 18 months of probation. Pursuant to Texas Code of Criminal Procedure, Article 42, a .302, which allows confinement as a condition of community supervision, Judge Fletcher ordered her to serve 30 days in jail. However, due to her being 9 months pregnant, the court exercised discretion, allowing her to serve the 30 days within the next 6 months, so she does not have to give birth in a jail cell. Additional conditions mandated by the court included a license suspension, a $2,000 fine, the installation of an ignition interlock device, Article 42, and mandatory attendance at a victim impact panel. The state could not proceed with a charge of intoxication manslaughter section 49.08 because the collision was initiated by the other vehicle. Although toxicology reports confirmed the presence of cocaine, marijuana, and alcohol, the law requires a strict causal link. Under Texas Penal Code Section 49.08, a person is guilty only if they cause the death by reason of that intoxication. Texas law places a high burden on the state to prove causation. Specifically, under Texas Penal Code Section 6.04, a person is criminally responsible only if the result would not have occurred but for their conduct. In this case, witnesses confirmed that the deceased driver cut directly in front of Ms. Sanchez. The prosecutor conceded that the accident was unavoidable, meaning the crash would have occurred even if Ms. Sanchez had been sober. Legally, this constitutes a concurrent cause where the defendant's conduct was clearly insufficient to cause the result. Because the state could not satisfy the but-for causation requirement for intoxication manslaughter, Ms. Sanchez was convicted of the underlying offense of driving while intoxicated. Judge Fletcher, bound by the statutory limits of this Class B misdemeanor, sentenced her to strict probation conditions and the 30-day jail term to begin post-pregnancy. Our second hearing we are reviewing occurred on October 18, 2024. Defendant Nicholas Michael Poole was charged with a terroristic threat on September 20th, 2024.
You are on bond for an evading arrest, a criminal mischief. You've picked up an aggravated assault of a family member and now a terroristic threat? We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The defendant is the complainant's ex-boyfriend. During a walk-in report, the complainant told the officers that her and the defendant had an on and off dating relationship since the 8th grade, but they broke up in June 2024. In September, the defendant told the complainant, "Stop talking all that mess before I come to your house and fucking shoot you." The complainant told the officers that right after the incident, the defendant sent her photos of a gun in his lap. The complainant stated the defendant also told one of the complainant's friends that he was going to shoot the complainant.
So tell me about the ag assault. What happened there?
Your Honor, in the ag assault, one moment.
In the criminal mischief, is it with the same complaining witness as well?
The criminal mischief's from a prior event where we had experimented trying a drug and kind of got crazy and broke stuff with it.
Yes, Your Honor. And then for the aggravated
Completely
assault,
unrelated.
it says the complainant and her friends went to a party, and at the party, they saw the defendant trying to get in, but was ultimately turned away because too many people were there already. While walking, the complainant ignored the defendant, and the defendant stated, "Are you going to apologize?" And the complainant kept walking. The defendant began cussing at the complainant and said, "I got it on me." And the defendant said the complainant said at that time, the defendant got a pistol from his ankle and pointed it at her. And then witnesses corroborated the complainant's statement. And Your Honor, there's also a pending terroristic threat out of Galveston as well for the same complaining witness. Yes.
Did you know about this?
I did not know about that.
Do you have an open case in Galveston as well? I think, Mr. Poole, that you are a complete and utter danger to our society. And I'm going to do everything in my power to protect Harris County from anyone that does any kind of damage whatsoever. I am now revoking your bonds on both of your other cases. Goes with you. I'm sorry. As much as I love you, it's unacceptable the way things have been going. And I think that you don't get the message. And now I hope you do. But I am now going to give you home confinement. You're not allowed out if you bond out of jail. I'm going to make your bond sky high. I think that you're a complete and utter danger to everyone. You flaunt our bond conditions. And it truly sad, Mr. Poole, because you have but one life. And when you have a gun and when you start using that, God forbid that you do some irreparable damage, that you dig yourself into a hole where you're looking at 50 to 60 years in prison, perhaps life. 99% of people that are in jail are there because they have no self-control. They either use something, they are on something, and they get upset,
They wig out without thinking, if I say this, what's going to happen? If I do this, what's going to happen? It's unacceptable. And now I will do everything, like I said, in my power to protect Harris County. So if you do get out, you must remain home confinement. You're not allowed out. No weapons, no contact with any of the complaining witnesses whatsoever. No dope, no alcohol. Anything else? I mean, what does he do?
He's a student, Judge. He's a high school student. So
I don't know what to tell you, man. I mean, he scares me. Are you mom and dad? Come on up, come up. It's out of control. I don't know what else to do. But it seems that when he's out in public and he's out, partying, as they say, there's a wake of trouble. Did you guys know that he has a case in Galveston as well?
No, Your Honor, this is the first time I've heard of that.
Is it currently open?
It's currently open, Your Honor.
Something that the lawyers are also unaware of as well,
We think it's all one event that happened over a few hours. We don't know.
But it's not though. It's not. He's, 12 in December of 23, we have a criminal mischief, an evading arrest. Now, a couple months later, we've got Galveston. It's not. And I think that we need to really give him a wake-up call before he really does irreparable damage,
If I could just clarify, the two events here in Harris and the one event in Galveston, we think that was all in the one series of events that happened between football games and a party on a hotel.
We need to figure out what's going on, to figure out why it's continuing to happen. I want what's best for your son. I really do. And I will help you in any way that I can. I have to put him in custody today because I have to show him that it's unacceptable what he's doing and picking up these two new cases, especially the fact that he's picked up an aggravated assault. That's, you've got a great lawyer. We'll be here to figure it out with you.
And Judge, he's already addressed the bond on the felony case as well. So he's gone in and addressed it with the felony. We're just
Bond, huh?
understood.
So I'm making your bonds 30,000 each. I don't know if they're going to bond you out, but if you do get out, you better be on your best behavior, and you are not to go anywhere. Some kids are harder to reach, but we'll do everything on our power to reach them one way or the other. So we got you. Okay. We'll take care of you one way or the other. Okay. All right. He goes with you. Oh yeah. I'm going to do a mow-up. So hold on, Stephen, hold on. Mr. Poole, I'm entering in what's called a magistrate's order for emergency protection that identifies SM as a protected individual. You're not to commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where this person works. If you violate this court order, the state can and will file a violation of protective order, and you violate those conditions, I can have a hearing to hold you at no bond. Zero bond, and I will do it in a heartbeat to protect every person of Harris County. Do you understand, Mr. Poole?
Judge Fleischer revoked the bonds for the two prior charges, taking Mr. Poole into custody immediately. The judge set new bail at $30,000 for each charge. Unlike the previous hearing, Mr. Poole is not just facing a new charge, he is facing the consequences of violating his bond conditions. Mr. Poole was already out on bond for evading arrest and criminal mischief. Article 17.40 of the Texas Code of Criminal Procedure allows a magistrate to revoke a defendant's bond if they find, by a preponderance of the evidence, that the defendant has violated a condition of bond related to the safety of the victim or the community. However, Mr. Poole has now been charged with aggravated assault of a family member section 22.02 and terroristic threat section 22.07. Regarding these new charges, Judge Fleischer issued a magistrate's order for emergency protection. Under Article 17.292, this prohibits the defendant from committing family violence, communicating with the victim, or possessing a firearm. Violating this order is a separate criminal offense punishable by immediate arrest. Finally, Judge Fleischer exercised his discretion under Article 17.15 of 5, which mandates the court consider the future safety of the victim and the community. Based on this, he set the bail at a sky-high amount, $30,000 for each charge. Furthermore, pursuant to Article 17.44, the judge ordered that if Mr. Poole manages to pay this bond, he must be placed under strict home confinement with GPS monitoring to ensure strict compliance. The final hearing we are reviewing took place on December 5, 2024. Defendant Jamarcus Antoine Jones was charged with a bond violation.
I understand. Filling in. I have had a chance to look at this violation report regarding Ms. Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7, within that 7 are included. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all. Cold weather. I apologize. So can I please speak on the breathalyzers?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No. It's you.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for alcohol.
Early
Test. And he is blowing outside the window, so we don't know what he's doing.
My God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
And you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I had a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, Anklemon. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I would wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one
I started
after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond?
Of course.
Oh my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, respond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. All right, 7502.
Judge Fleischer applied Article 17.09 to declare the bond insufficient. He raised the bond amount to $10,002, resulting in Mr. Jones's immediate incarceration. Initially, the defense attempted to explain the violations by arguing that Mr. Jones went to sleep at 8 p.m. and therefore missed his nighttime check-ins. However, the hearing took a sharp turn when the sheer volume of missed tests was revealed. Article 17.441 of the Texas Code of Criminal Procedure mandates the installation of an ignition interlock or portable breathalyzer. These devices require the defendant to provide breath samples at scheduled times to prove sobriety. The report indicated that Mr. Jones had missed 19 required tests since November 15th, in addition to previously testing positive for marijuana and opiates. Under Article 17.09, Section 3, if a judge finds that a bond condition has been violated, the bond is deemed insufficient. This statute gives the judge the absolute authority to order the defendant's immediate arrest and incarceration. Facing this reality, Judge Fleischer refused to rely on the defendant's excuses about having a cold or sleeping early, noting that the defendant appeared to be intentionally fooling the camera on the device. Rather than finding cause for leniency, Judge Fleischer exercised his judicial discretion to enforce zero tolerance. He determined that the defendant's consistent failure to comply with court orders outweighed the defense's pleas for another chance. These hearings underscore why judicial responsibility is such a vital safeguard in our justice system. When a case comes before the court, a judge's rulings carry immense weight. They determine not only how the law is applied, but how justice is perceived by the community. Each decision must be rooted in evidence, guided by principle, and delivered with the seriousness that accountability demands. Judges who approach each case with diligence and resolve demonstrate why firmness on the bench is essential. A judge who carefully considers the facts, holds individuals accountable for their actions, and refuses to be swayed by pressure or convenience helps ensure that justice remains consistent and meaningful. This firmness reinforces the principle that responsibility is not optional in a lawful society. It is a cornerstone of fairness and order. Their decisions remind us that actions carry consequences, and that the justice system functions best when those consequences are applied with integrity. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can foster a more informed society.